AM 650 presents You and the Law, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, hello, and welcome to You and the Law here on AM 650. On today's edition of the program, we're going to focus on family law. Oh, yes, this is one that we've been waiting to bring to you, friends, and particularly family law as it pertains to the new Family Law Act and its impact on marriage agreements, children's issues, and mediation. And to help us sort it all out, we are delighted to welcome to our studio and to You and the Law, Angela Thiel and Christine Eilers, both from Lindsay Kenney LLP in Vancouver. Angela, welcome.
Thank you.
It's good to have you with us. Christine, nice to see you too.
Nice to see you also.
Well, tell us a little bit about yourselves. Angela, you're a partner at Lindsay Kenney. Tell us a little bit about your background as a lawyer.
I have done general litigation all the way through. I have a lot of work in family law as well as some other areas. I've been with Lindsay Kenney about 23 years. I've been a lawyer almost 30. Grew up in Vancouver, went to law school in Vancouver. I really enjoy what I do.
And general litigation means you
Well, in the family law area, we try not to go to court a lot.
Right.
That we really do hope people will resolve their issues. But yes, generally there's a lot of court time.
All right, Christine, you're not yet a partner with Lindsay Kenney.
That's
you're
correct.
an associate with the firm
I am.
so far, a rising star. Tell us a little bit about yourself. Are you a Vancouver person too?
I am born and raised on the North Shore.
Okay.
And also went to law school at UBC. I started at the firm May 2010 as an articled student, and I've been there ever since, so practicing primarily in family law.
Okay.
I'm one of those weird people who wanted to do that before law school. And I also practice in some other areas, other general civil litigation areas.
So why did you want to do family law even before you went to law school? What had you leaning in that direction so early on?
Well, my parents would love me for saying this. They went through a pretty ugly divorce, and I suppose I had idealistic vision of making a difference.
Okay. So personal experience.
And I like the stories.
Okay. Well, I'm looking forward to stories from both of you. But there's really a lot on the table on this edition of You and the Law, and we've been looking forward to doing a show with you on family law. And Angela, tell us about the new Family Law Act in British Columbia. It's literally brand new. It's only been on the books for, 2 or 3 months?
It came into force in March 2013. We knew about it. We knew what was going to change probably for a good year. It had been in the works with the Attorney General since about 2002. BC, I think everyone felt, was a bit behind the times. The statute in BC was anomalous to other provinces.
Well, what did it replace? What was the last Family Act in BC?
The Family Relations Act started in 1979.
Oh, my.
And so there haven't been that many significant changes in it, even while I've been practicing law. I think the most significant change was that they put in pension legislation as part of it in 1995.
So the whole thing was due for an overhaul.
Definitely.
Okay, so now we have it.
That's correct.
What's the big difference in 2013 from the previous family law that we know in British Columbia? What's the big change?
Well, there's two significant big changes I think everybody would tell you. The first is that common law couples are now recognized as husband and wife with the same property rights as married people always traditionally had.
Okay.
And a lot of people in British Columbia have always thought, oh, well, I'm no different. If I live together, I still get a piece of his pension. I still get a piece of this house.
Right.
Well, that's never been the case
Really?
In British Columbia.
But why have most of us thought it that way then?
I think just people, their employer says, oh, you can put your common law spouse on your benefit plan after 6 months.
Okay.
People... They don't have to talk to a lawyer until they have a problem. And a lot of people just assume that if I'm here and I'm contributing financially, even if the house is in your name, I still get a piece of it. Well, the law prior to 2013 is you had to prove your contribution to something in somebody else's name. You didn't get a piece of their pensions and RSPs automatically.
Okay.
That has all changed. And more particularly, it's changed sort of from the date you start cohabiting. You're not considered legally common law for 2 years, but you will get a piece of everything from the date you start cohabiting. And then the second big change is that we used to have a system where as you walked into a relationship, prima facie, into a marriage, prima facie, everything that the other party had was half yours
Right.
on the date you came
Right.
in.
Okay.
So what this new act has said is what you have going in, you can protect, and you're only going to split what things go up while you're together. So it's for most.
So you don't automatically, and I hate to use the word because it's terribly unromantic, but you no longer forfeit half of what you own or possess by entering into a marriage anymore.
That's correct. But if you don't take some pretty obvious steps to make sure that you can prove what you had when you walked into this relationship, you're going to have some difficulty.
So the act allows you to do that now,
That's
though.
correct.
You can say, Christine, for example, okay, I come into this new relationship with the following, and if you can identify that up front, and the other person says, yeah, that's true, then you're good to go based on the new changes, right?
That's correct. But a lot of people will say, well, I don't really want these new changes either. I don't want to share appreciation on this particular asset.
Okay.
So there's provisions in the new act that make the entering into an agreement much more effective for people. To actually say to judges, if we entered into an agreement, please don't, decide that it's not fair to one of us 10 years later. So big changes in terms of most people will be within a certain framework. They'll say, they'll come in and you'll say, well, if these are the facts, this is what's going to apply to you. Now, if you want something else to apply to you, there is some judicial discretion, but you really want to spend all the money to go to court to see if that judge decides in your favor.
Right, right.
So that's, and a lot of the problem areas we had, things like gifts from parents and inheritances, those are all spelled out as being yours. Again, you better document them.
Right.
But if you document
But
them,
according to the new act in BC, that's now defined as capable of being yours and yours alone.
that's correct. And no more tests of, did we use this money for a family purpose,
Right.
which always caused lots of litigation. No more arguments about, well, did mom and dad give that to both of us? Was that a loan? Was that a gift? Do we have any documentation? A lot of the areas in which there was dispute, this statute has tried to set out, here's how we're going to solve those problems. You may not like the way the statute solves it,
Right.
but it's going to be solved, and there's not a lot of incentive to go to court and say to a judge, well, can I fit in this narrow exception of people where you think that's just significantly unfair? And so the impetus was, let's reduce litigation. We'll see how it works.
Okay. Now, Christine, Angela said straight up when I asked her about her litigation experience, which caused a huge smile. I get the feeling you like going to court. But now you did say, Angela, we try as often as possible not to go to court. So, Christine, what are the alternative remedies for people in dispute who don't want to go to court, that in fact the system is now appearing to be designed to appeal to?
That's right. Certainly one of the big things with this new act is a bigger focus on out-of-court resolution.
Yeah.
Specifically, the act is dealing with things like mediation, arbitration, collaborative family law, and parenting coordinators as well. So all of that is new in terms of actually being referenced in the legislation.
Okay, so now this is part of the act. They identify these various categories of dispute resolution. Is it the preference of the courts that you don't show up unless you've really got something important? In other words, the less frivolous nonsense brought before the court, the happier everyone is. Is that the case?
I think it's fair to say that there are probably more self-represented family litigants in the court than there are people represented by lawyers.
Really?
So the court struggles mightily with people that come to court saying, well, we can't decide, so you judge, please decide. I don't know a lot of lawyers who think that court resolutions are the best things for their clients.
Right.
No.
And I certainly don't. Sometimes you have no choice. You can't mediate something. Normally, it's because there are children involved, and you have to ask the court.
And the other issue is the courts are pretty backed up currently.
Exactly.
And
there's a sort of chronic shortage of judges and the whole bit. Okay.
So if you can resolve it outside of court with a mediator or an arbitrator or a collaborative lawyer, what have you, in a set period of time, and you might be paying a bit of money to do that, but at least you're not sitting around waiting for a judge that may never come, at least on that day.
So the idea, though, be whether it's collaborative law or an arbitration or a mediation process, it'll likely cost you less because there's no actual court costs involved, and B, it should expedite some kind of resolution. You should resolve your differences faster than waiting for a court date, correct?
Well, we don't really have court costs in the sense it costs us very little to use a courtroom. But the idea of if we go into court on a particular day and it's overbooked,
right,
we can actually, as a lawyer, sit there all day and say to the client, I'm sorry, we didn't get a judge, and unfortunately you have to pay me for that day I just sat there.
Yep.
Now, what you try to do is use that time effectively and hope you can resolve it while you're waiting for a judge. And the other thing is that the average judge is really, really good, but most of them have a family law specialty. And one of the judges once said to me, well, would you ask a stranger what to do with your kids? Well, I'm just a stranger at the corner of, Howe and Smythe. Why do you want to ask me how to raise your kids?
Right.
So let's try to make the decisions ourselves with the aid of some qualified professionals.
Well, this whole category of law is really under the umbrella of emotion, isn't it? Because whether we're talking about the net results of a relationship in terms of accumulated wealth, children, property, all of those other things, and possibly some acrimonious feelings, especially with the children involved, or the emotion at the front end of any relationship, the oohs and ahs of being in love. So all of the issues involved in family law, I would think, maybe I'm being oversimplistic here, but they are as a result of a surplus of emotion. Now, am I being a little too analytical here, Angela?
No, not at all. And one of the most difficult things to be in terms of trying to be an ethical lawyer is having to repeat over and over again, I know you're angry, I know you're hurt, I know you're upset.
Sure.
But here's what is going to happen when we go to court, and I don't want to take your money to have a judge tell you what I've just told you. So the hardest part of this, in my view, is ethics. And sometimes a client comes to you and wants to hear a certain thing, wants to hear you're going to punish her husband for infidelity.
Yep.
And that the court will give her more because of that. And I have lost clients because I don't tell them what they want to hear. I tell them what they need to hear. Right.
So if an angry spouse comes to you and there's infidelity allegations flying all over the place, and there's a need for revenge, there's a real visceral anger involved, well, the court isn't going to provide, even with the most expensive lawyer in town, Angela, the court isn't going to punish somebody for malfeasance, cheating, or whatever. They're going to deal with it in a legal fashion. And that's all that's going to come out of it, isn't it?
That's correct. And people sometimes want to get on the stand and tell their story.
Oh, yeah.
And, I see a lot of cases where often it's self-reps because the lawyers have said, you don't want to pay me if all you want to go do is beat up on your husband verbally in court.
Just read that anger into the record.
Exactly.
Right.
Exactly.
Okay. So, but what's that famous Mark Twain line about he who represents himself has a fool for a client?
Yeah.
I mean, I tend to buy into that. I would be terrified to represent myself in court. No matter what a lawyer might charge, I would feel so alien, so out of my element, no matter how angry and self-righteous I felt. I think I would be my own worst enemy in that environment.
You generally are, but the people that want to do it because sometimes they can't afford a lawyer.
Of course.
Okay.
But there are those people who are sort of professional litigant types and will say, well, I can get back on my spouse by, continuing to take them to court for frivolous matters, and they either have to, hire a lawyer themselves, or they have to figure out how to do it themselves as well.
Yeah, Christine, you have some training in collaborative law. So how do you take a person, an emotionally charged person, who's just spitting mad and wants some revenge? How do you take that person and convince him or her that while I understand how you feel, you're not going to get the satisfaction you're after, regardless of how much money you spend. So how do you convince that angry, bitter person to take a collaborative or mediation approach? Talk them down, as it were, off that really emotional anger high.
Well, yeah, that's exactly what you're trying to do for the most part. And I think the biggest thing is gaining the trust of your client and showing them that you understand why they're, emotional. And of course, all of our clients are coming from that perspective for the most part.
Absolutely, sure.
But really that's not going to help them in the long run. And there's certain things that are just going to happen whether they like it or not, unfortunately. And it's about dealing with it in the best possible way and providing the healthiest outcome for their children, if they have children, and even for themselves and their financial well-being and their, whether they care about the relationship with their ex or not.
Right,
But just for all their relationships and their well-being in general.
I imagine the persuasive process, though, to both of you must be tough. When some of the, and you even talked about, in your own personal circumstances, the acrimony is palpable. It's scary how angry people get at each other. And so to try and talk them down from that really high-strung, I don't imagine it happens in 15 minutes or less. It probably takes a few sessions, right?
Sometimes, yeah. People often get it pretty quickly when you tell them, this is the way it's going to be one way or another, and the realities of the situation. People do often understand it fairly quickly, I think.
And sometimes you have to say, well, I know this is really terrible, but, you have two beautiful children, and you have a home, you have assets, and we really don't want you to deplete those assets arguing about, how unhappy you are.
Right.
And sometimes you say, well, yeah, he was a real jerk, but, my other client here, this is what happened to her.
Right.
And what's interesting sometimes is that sometimes the clients who have had the most difficult personal circumstances rise above them, and other clients, it's just a matter of coping. And if people have kids, you really do focus on, this is the man you chose to have children with,
Sure.
or this is the woman you chose to have children with.
Right.
You're going to remain connected to them. You want to make it ugly now, it's going to be ugly for 10 years.
Yeah.
I always tell the story about, do you want to be sitting at your child's wedding and not being able to talk to the father or mother of your child
Exactly.
because there's still so much ugliness?
Yes.
And, you have to think long term.
Interesting. Sorry, Christine, if we need to take a break, but finish it off here.
Well, I was just going to say the other thing is when you mention the potential costs of a long trial,
Right.
people change their tune pretty quickly.
Yeah, well, when you hit them in the bank account, you at least have their undivided attention, right? This is You and the Law here on AM 650. It's Family Law Show Day, and boy, we're just getting started here. We're going to talk about marriage agreements. What? Marriage agreements with our guests, Angela Thiel and Christine Eilers from Lindsay Kenney LLP, when we return here on AM 650.
This is You and the Law. There's more of the show still ahead on AM 650.